Mickey Truth Girl. Who qualifies her to put a work on these people?
What's up, y'all? It's your girl, Mickey Truth, aka the Queen of Paperwork, and I am back with another video. As always, all information contained in this video is for entertainment, educational purposes only. All information used in this video is per the Fair Use Act, and any conclusion that you draw is on you, not me. So let's get it. I was scrolling through YouTube and I saw that Truth Teller was speaking on RondoNumbaNine new appeal, and I said, "Oh, I wonder if CDai has gotten a decision on his appeal, right?" So I went over to the appeals website. However, the only appeal that's available, well, new appeal, will be RondoNumbaNine. CDai's is not available. I'm not going to go in detail about the whole appeal because, again, this is 19 pages, okay? But it's more so that let's get into the opinion of it, okay? So this is what it says. Defendant Clint Massey, age 17, and co-defendant Courtney Ely were both convicted of first-degree murder in connection with the shooting death of taxi driver Javon Boyd on the night of February 21st, 2014. In addition, the jury found that the state had proven beyond a reasonable doubt that the defendant, or one of whose conduct defendant was legally responsible, was armed with a firearm during the commission of the offense. However, the jury did not find this allegation was proven beyond a reasonable doubt with respect to Ely. So for those who don't know that part, basically they convicted, okay, both of them for the murder, but the only person that the jury found to have possession of a weapon during the offense is RondoNumbaNine, that not CDai, and you can verify that if you just listen to the audio of CDai's appeal, which is available for anybody to look online. Okay, and it's on my page actually, right? So it further goes to say, since the defendant was 17 years old at the time of the offense, the trial court had the discretion to impose or not impose the sentencing enhancement. The trial court sentenced defendant to 24 years plus a 15-year firearm sentencing enhancement for a total of 39 years with the Illinois Department of Correction. Defendant's conviction was affirmed on appeal by this court on June 4th, 2019. In the present appeal, defendant challenges the dismissal of his attorney-drafted post-conviction petition as frivolous and patently without merit. Defendant, who continues to be represented by an attorney, raises 4 claims on appeal. 1, actual innocence, supported by the affidavit of an eyewitness, Anton Kennerman. 2, prosecutorial misconduct on the ground that a witness recant at trial demonstrate that prosecutors must have fabricated her pretrial statement. 3, a Brady violation on the ground that prosecutors allegedly concealed an alleged deal with a trial witness. And 4, ineffectiveness assistance of counsel on the ground that trial counsel allegedly failed to investigate alibi witnesses for the following reasons we affirm. All right, so that is the grounds that this appeal is for. And it goes in, we done went over this a bunch of times over here on my channel. Not going to go into the background of it, but feel free to go check it out yourself, okay? Let's see what else we got going on. And then if you go down to here, say a single jury found both defendant and Ely guilty of first-degree murder, but found the firearm allegation proven only with respect to defendant, as we just said. It then goes on to say, on appeal, defendant argued first that his trial counsel was ineffective for failing to more vigorously pursue a theory that Ely was the sole shooter. So in regards to that, it's a lot of questions, right? So again, on appeal, okay, the defendant, his lawyer, however you want to word it, is saying, hey, why wasn't the theory used that CDai did it? He was the only one who did it. It was a lot of conversations, even in the appeal for CDai, right? The state stated you could see a light or a flash coming from the hands of CDai, right? It also said that one of the witnesses not only pointed out RondoNumbaNine as a shooter, but another witness pointed out CDai as a shooter. So it was kind of like a toss-up depending on who you want to believe at the time, right? And they said that's according to Massey Appeal 2019 and gives the number, okay? Second, defendant argued that the trial court erred in allowing Detective Halloran to testify. After Jasmine Brown denied that officer recovered photos from her phone, Halloran testified that Brown told him that she had pictures on her phone showing defendant and Ely wearing the same outfits that they had worn at the time of the shooting. Now, I will say this. Well, I'll get into that in a minute. Just remember the name Halloran, okay? And then it says that Brown gave him the phone and signed a consent to search form. The state showed the jury these photos, including a photo of the defendant wearing the orange and black stripe matching outfit that Brown had indicated the defendant was wearing at the time of the shooting, which is included in his previous appeal. All right. Third, the defendant argued that the trial court erred by declaring a mistrial after an outburst from the victim's family. That's also in a previous appeal. Lastly, defendant argued that the trial court committed reversible error when it failed to give him notice prior to the hearing of which Johns was declared a material witness. Johns was a homeless young lady that they jailed in order to testify at trial. Okay. And again, you can read this yourself. That appeal is available online. All right. So it continued to say that on October 12th, 2021, defendant filed an attorney-drafted post-conviction petition. Attached to the petition was typed, sworn, and notarized affidavit of Anton Kinnerman, which stated in full, and it goes to say, I have material information relevant to the above specified case on February 22nd, 2014, at about the early morning hours on 37th and Princeton in Chicago, Illinois. I was walking past a Gold four-door car with a man in it, with a car full of people falling close by. A white van and another car drove by the gold car, and all three U-turns in front of me. It then goes on to say, I saw a man I known as Marks Alonzo Watkins, see attached photo, exit passenger door of the white van with a handgun. Who the hell is that? Walk up to the gold car and fire shots in a gold car at Javon Boyd. So who the hell is Marks Watkins? This is a whole nother person. Now, y'all know, I'm not going to sit here and say I have dug into this case like that, but that's the first I've heard of that name. But hey, they said this statement was provided. Let's see what the fine print says at the bottom. Okay, the footnotes. It says the affidavit was notarized by the defendant's attorney, who also represented him on this appeal. In the attached affidavit, the official last name is typed Kinnerman. However, the trial court spelled the last name, I guess it was a misspelling. Okay, cool. We keep on. So again, typos. Boom, 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 boom. Okay, it continues on. It also goes on to say the petition also attached alibi affidavits from three people, and said that they swore the defendant was at home with them during the relevant time period, and that an investigator who worked on behalf of defendant's trial counsel interviewed them prior to trial. So again, that's what they have on there. Now, it goes on to say on December 22nd, 2021, in a 7-page typewritten order, the trial court dismissed the post-conviction petition as frivolous. So again, they're like, yo, fuck all that shit. Y'all with that bullshit. Okay. And they again said that even with his affidavit, Kinnerman's affidavit, it wouldn't change the result of the trial, because 3 witnesses placed the defendant at the scene, and there was surveillance video of the crime, which again showed the person the witnesses identified by his outfit. So it said the trial court found this claim frivolous and without merit. Nonetheless, see how again people point saying, "Yo, I know who that is." Da, 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 da. Yeah, that's what that's about. All right, let's see here. All right, fabricated pretrial statement of Takia Herbert. Okay, it kind of went into that, I believe, it the first time. They said again, frivolous and without merit. I'm just verifying, going over here. So I'm not gonna read through everything because a lot of it is just repeat from the one before. But again, make sure you go check it out for yourself. All right, let me see. Actual innocence. Again, they're saying he was at home They have 3 witnesses saying that. New evidence. 2 video shows the victim's cold car robbing at 3:36 and stopping in the middle of the street. It says in the footnotes, it says, although the victim's car was apparently beige, it appears to go under the nighttime street lighting in the videos. Okay. All right. I kind of want to get into the part that's talking about the CDai being the sole shooter aspect. Okay, so now we're really getting into that. But it says, in conclusions, for the reasons explained above, we find that the defendant's actual innocence claim based on the Kinderman affidavit were properly dismissed as frivolous and patently without merit, where a significant portion of his affidavit, okay, is refuted by surveillance videos of the shooting. In addition, we find his remaining claims do not warrant extended discussion and are also patently without merit, affirmed. So basically, withholding or upholding the conviction. Now, like I said, CDai also did file an appeal. And he actually told me that himself. So give me 1 second. I got to log in. I thought I already had it up, but I don't. Here is from Courtney Ely, aka CDai. This was back when the whole Tay Capone situation was taking place, right? And I reached out to say, hey, what do you feel about it? This is my thoughts on it. This is what I came up to, and this is his response. He says, my decision on my case and facts pertaining to it will soon be posted on the Court of Illinois' First District website. I am currently waiting on the judge's decision, which will be made any day. My case number in the appellate court is 1-22-1748, which you can call the First District Clerk Office to confirm or ask any questions. Hopefully, once the judge orders its decision, that will answer any questions that you have. Okay. And that again is according to CDai. Okay. So let me ask you this, because when I tried to just look it up online, but only the 2019 appellate decision. Do you know why the other ones are not coming up? Because I do know it should be a recent one too for 2023.
Probably because it's not done here. It's done in Springfield.
Okay.
And that's who puts it online.
Gotcha.
I mean, but what you could do as far as you want to copy the decision is come to the office, and it would be like 25 pages. Do you have that case number? Okay, how many pages it is?
Yes, I do. Give me 1 second. I got it. It is, well, actually, it's from 2022. It's 1-2022. Well, no, hold on. 1-22-1748. Okay.
Yeah, this case, so a decision of the court is not rendered yet.
Okay.
You know, it's giving a case ready, but he just filed something on 10/25. So they most should be to file a supplemental reply brief. So that was just filed according to 10/25, and they put the case in case ready 10/23, which means they have everything to make a decision, but will never come down.
Right.
Down notification.
Okay. So, like I said, that was back from November 6th, and CDai appeal had not had a decision made on it. So maybe a decision has been made on it, maybe it hasn't, but for now, that's the update. I reached back out to CDai though to see if he did hear something. However, I have not gotten a response yet. Like I literally just did it while I was recording this. So when I get an update, I'll give y'all an update. With that being said, make sure you like, comment, share, subscribe, tell a friend to pull up on your girl, Mickey Truth. And as always, donations are welcome. Hit the cash at $ Mickey Truth 2022. Holla! No matter what you go through, do what you got to do and conquer the world.